if you wish to try and correlate it with law and try and fix it with the legal system, I'll give you some examples. Acts of corruption include anything made punishable under Chapter 9 of the Penal Code or under the Prevention of Corruption Act, which would also include any offence committed by any elected member of the House of Legislature, even in respect of his speech or vote inside the House. This is their definition of corruption. They have also included some other definitions. After that, what I believe is the most amazing aspect of this document, notwithstanding anything in any other act or law, the provisions of this act shall prevail, and to the extent that the provisions of this act are repugnant to any other provision in any other act or law, the provisions of other acts or law shall stand amended to the extent of such repugnancy. So the Ramlila document will prevail over every other law in this country, every law which has stood the test of 60 years of judicial scrutiny, every document, every bill, every act that has been passed by Parliament is subservient to the Ramlila document. Which document nobody has read so far, because the spokespersons of the Ramlila document, the people who come on television, the event managers of the Ramlila document, all of them talk of trust deficit, but nobody has the intelligence to read this document. I'll come further. They say in section 7 clause 10, only people with impeccable integrity and record of public servants, particularly in the field of fighting corruption, shall be eligible for being considered for nomination. All of us will be out of here. We cannot be nominated in this thing because our impeccable integrity will never be we'll never be persons of impeccable integrity. Now, after that, Usha has briefly mentioned the powers and functions of the Lokpal and its officers. If you were to look at section 6, it is the most amazing. Firstly, I don't think they know the difference between powers and functions and mix them together. But even otherwise, the Lokpal has the power of investigation. While it has the power of investigation, it has the power to recruit investigating officers and staff and get them trained in modern methods of scientific investigation. The Lokpal, after completing investigation, has the power to impose punishment or dismissal, removal or reduction in rank against government servants. So post-investigation, it will take on an administrative role. It has the power to initiate prosecution before a special court established under the Prevention of Corruption Act. And while doing that, it has to ensure the proper prosecution of cases, as though cases which are being prosecuted so far have been improperly prosecuted. Then they will authorize the bench of the Lokpal to issue letters rogatory in relation to any case pending investigation under this Act. What is a letter rogatory? It is a formal request from a court of law to a foreign court to provide assistance of some kind. But this super court, which is neither a court nor does it exercise sovereign powers of the state, will now have the power, in contravention of all international conventions, to issue letters rogatory. And which foreign power is going, or which foreign court is going to respond to that? We do not know. So section 166A, 166B of the Code of Criminal Procedure have all gone, because the Lokpal will now issue this issue letters rogatory. Then it has the power, and I think this is quite amazing, to appoint judicial officers, prosecutors and senior counsels. I told my colleagues in office, they may as well appoint defense counsels also. It is so simple, because you've decided you're going to punish a set of people, you appoint the worst defense counsels in town, make sure the man is convicted. It's very simple. So they have the power to appoint judicial officers, prosecutors and senior counsels. So what does this section 6 say? We have the power to investigate, we will appoint our own investigators. We have the power to prosecute, we will appoint our own prosecutors and judicial officers. We have the power to punish, because post-investigation, we will make sure that the delinquent officer will be removed, dismissed, reduced in rank. How beautiful. Everything in one person. Then they don't stop here. They want to prepare a sentencing policy for offences under the Prevention of Corruption Act and revise it from time to time. Have you heard this anywhere before? Sentencing policy. Now, it's not enough for the Lokpal to investigate offences of corruption and that narrow definition of corruption which they haven't expanded under the Prevention of Corruption Act. It is very important for the Lokpal to transgress into other areas. So what do? Foreign Exchange Management Act, Prevention of Money Laundering Act. We will take over the systems of those two acts as well. So the ED, Directorate of Enforcement, goes by the wayside. The entire system set up by the Prevention of Money Laundering Act. And I may add, it's a reasonable act. The Prevention of Money Laundering Act, which came into force in 2002, is a significant act. It actually prosecutes persons who have committed crimes and actually prosecutes them on the basis of proceeds of crime. But that's not enough for the Lokpal. They will take over the powers of the ED with respect to FEMA as well as with respect to the Prevention of Money Laundering Act. Now, they will exercise quasi-judicial powers. They will summon people. They will enforce the attendance of any person from any part of India, examine them on oath. I'll conclude by talking about accountability of the Lokpal. Section 11 is quite brilliant. The chairman of the Lokpal can be removed if he is guilty of misbehavior. We don't know what that means. If he is unfit to continue his office by reason of infirmity, if he is adjudged insolvent, or he engages during his term of office, it is for all of us.
And then made entire relationships among societies, among man to man, woman to woman, and the families, absolutely brought in no kind of equality. And then saying this is what that we want the freedom for. And when Ambedkar had said that these are not the issues, there are other issues also we need to take, and in this whole form that you will have to take also these particular issues, then we started to say, no, sorry, these are the issues that we cannot do it now, we will do it after the whole independence comes. And today, actually in the initial stages, the Dalit organizations and the Adivasi organizations are not sure, but many of the Dalit organizations were at a dilemma initially, but then I think slowly that particular aspect has come, and today many of them and many of us are trying to say that this whole definition of corruption, definition of whistleblower, definition of how you are able to take this forward does not include our concerns and the concerns of the Muslims, concerns of the women and others. So therefore I think this is a time that we need to bring in a re-debate in this country, using this opportunity to say, is it possible for us to look at corruption not only as the financial corruption, but look at from the angle of bringing real equity and equality